Hello, my name is Costa, and in this presentation I'll go into the effects of intellectual property law in high-risk artificial intelligence applications. So what are high-risk AI applications? Well, the EU defines them as AI systems with the potential to cause social or environmental harm. And these applications more specifically can range anywhere from transportation, medicine, to legal systems. So what is intellectual property and why is it important in the context of AI? So, intellectual property is a category of property that protects creations of intangible works of the human mind, which AI falls under. The purposes of intellectual property is to encourage the creation of intellectual goods which benefit all of society. Intellectual property ranges from patents, copyrights, industrial design rights, to trade dress to trade secrets. But patents, copyrights, and trade secrets are most relevant to protecting AI systems. So going into copyrights within AI, most organizations protect their open source code and visible AI systems under copyright. And if you look at most open source code bases, you'll see a copyright protection clause at the end of the code base. This is because AI systems often have a context of authorship or artistry that's sometimes necessary to create them. However, this comes along with many problems because the purpose of high-risk AI systems is to have a certain functionality. But function is not protected under copyright law, and copyright law is more meant for things like literary works or paintings. So going into more problems with copyrights, most AI systems perform learning tasks without explicit programming from developers. And those developers often have limited control over the learned correlations of these systems, and this clashes with the requirement of copyright in that it needs to be the author's own intellectual creation. Also, copyright has limited practical protection ability because code can be easily changed or adapted to look completely new, yet carry the same valuable functionality that a company invested in. So now, as a result, many organizations and companies are falling on trade secrets to protect their high-risk AI systems. And this is now the most common way to protect these systems. The reason why they choose trade secrets is because if they have all the NDAs in place, it's very easy to keep them, since AI systems are not reverse engineerable, in that if you know how they work, it's very difficult to find out, or if you know what they do, it's very difficult to find out how they work. And trade secrets are also an inherently bad solution because they keep high-risk AI applications as private and undisclosed, and this reduces the transparency and accountability of these systems. So now going into AI and patents, AI systems are, for the most part, not patentable unless they control an external object, machine, or process. And many of these AI methods are based on natural phenomenon, like neural networks, which naturally occur in our brain, or abstract ideas, disqualifying them from patentability. And some algorithms do actually meet the specific criteria to be patentable, like Google's PageRank algorithm, but the exact implementation is again kept as a trade secret, which prevents further exploration into the harms that these systems can create. So the conclusion is that ownership of AI systems and their relating algorithms is caught in a deadlock between being too functional for copyright law, yet too abstract for patentability. And current intellectual property law in the United States creates an environment where very powerful and dangerous AI systems are kept as private coveted trade secrets, which further prevent transparency and accountability that are needed by those systems to prevent social harm. Possible solutions of this could be expanding patent laws so that algorithms and AI systems are included under utility patents as processes or methods. This is because algorithms are processes or specific steps to accomplish a goal. Another possible solution is creating a federal agency specifically for regulating algorithmics, because AI regulation is so technical and difficult to enforce. Maybe we need a specific organization for that. Another thing that the agency could do is inform and consult other agencies that are regulating AI, like, for example, the FTC. The last thing that we could do is create APIs, which could allow people to investigate these solutions. This is my citations, and thank you for watching.